In these past decades, we've seen an increase of global mobility within the work sphere. In this video, we will discuss how the Employment Tribunal deals with cases involving expatriate workers. The general principle is that UK legislation is only intended to be territorial in scope. The House of Lords in the case of Lawson and Serco, for example, commented that it cannot be the case that Parliament intends for statutory employment rights like whistleblowing protections to apply to employment anywhere in the world. The general principle is that an employee who works and lives abroad does not have a territorial connection with the UK unless if his employer is from the UK, but that of itself is not sufficient to establish a territorial connection. In this video, we will discuss two different scenarios of an expatriate worker and consider how the Employment Tribunal would deal with issues of jurisdiction and territorial connection. We will then finish this video by discussing practical matters that both claimants and respondents should consider in cross-border employment disputes. We'll now discuss the first scenario where we think the claimant will be able to demonstrate a sufficiently strong connection with Great Britain. Suppose the claimant is an engineer who works for a large multinational and is employed by the English subsidiary whose head office is in London. The claimant works for the multinational for a total of 3 years, the first 2 years in London, and in the final year the claimant is asked to move to Saudi Arabia to work under a very lucrative project. Under this scenario, the claimant's contract of employment is governed by English law, and payroll is dealt in accordance with UK tax and social security legislation. At all times, including in Saudi Arabia, the claimant is being paid in pounds sterling into a UK bank account, and despite moving to Saudi Arabia, the claimant still reports to his line manager in London, and HR decisions are also being carried out by the London head office. To begin with, we think the issue of establishing jurisdiction in the Employment Tribunal will not be difficult, given that the respondent is an English subsidiary whose head office is in London. And so the issue of jurisdiction is not a problem here. We also believe that the claimant will not have difficulties in establishing a sufficiently strong connection with Great Britain for the following reasons. Firstly, the claimant's contract of employment is governed by English law, and HR decisions are still being carried out in England. There have been various cases, such as the Supreme Court case of Ravad and Halliburton and the AAT decision of Hodge and Dignity Choice in Dying, where the tribunal or court took into account the fact that the claimant was being told that he or she would be protected by English employment law and were still being subject to HR decision-making in the London head office, which demonstrates a strong connection with Great Britain. Another reason why I think the claimant can demonstrate a sufficiently strong connection is because the claimant's salary is being paid in pound sterling, and payroll is being dealt in accordance with UK tax and social security legislation. And finally, another reason why the claimant can show a sufficiently strong connection is because the claimant under this scenario was posted abroad to Saudi Arabia to benefit the British employer's business. After all, the claimant was asked to move to Saudi Arabia to work under a very lucrative project for his employer. This is another factor that tribunals take into account in demonstrating a sufficiently strong connection, as shown by the EAT decision of Financial Times Limited and Bishop. And so in this case, we think the claimant can demonstrate a sufficiently strong connection and will therefore be protected by statutory employment rights like unfair dismissal, whistleblowing, and anti-discrimination. Let's now move on to scenario 2, where we will discuss some issues that expatriate workers frequently encounter in practice when trying to demonstrate a sufficiently strong connection. Let's change the facts of scenario 1 slightly. Imagine if the claimant had always lived and worked in Saudi Arabia. Let's also imagine that the contract of employment is governed by Saudi law, and the claimant's salary is paid under the local currency of Saudi Arabia, and payroll is dealt in accordance with Saudi social security and tax legislation. Under this scenario, we believe the claimant will fail to demonstrate a sufficiently strong connection for the following reasons. Firstly, the contract of employment is governed by Saudi law, which could mean that the claimant is able to enforce his rights under the local courts of Saudi Arabia. This is a factor that tribunals frequently take into account. For example, in the recent decision of Kuznetsov and ING Bank, one of the many reasons why the claimant was unsuccessful was because his contract of employment was governed by Russian law, and the claimant had even started to bring proceedings in the court of Russia. Another reason why I think the claimant in scenario 2 will fail to demonstrate a sufficiently strong connection is because his salary is being paid under the local currency of Saudi Arabia, and payroll is also dealt in accordance with Saudi law. This is another factor tribunals take into account. For example, in the 2022 decision of Rajabov and Foreign and Commonwealth Office, one of the many reasons why the EAT upheld the tribunal's initial decision that there was no sufficiently strong connection was the fact that the claimant was receiving his salary under the local currency of Tajikistan and payroll was dealt in accordance with Tajik law. Finally, another reason why I think the claimant under this scenario will fail to show a sufficiently strong connection is that the mere fact that he might still receive managerial inputs or administrative support from the London head office is not in itself sufficient to demonstrate a sufficiently strong connection. The Court of Appeal in the case of Credit Sites Limited and Duna, for example, commented that such arrangements often only exist out of mere administrative convenience, and it is simply not enough of itself to show that the claimant has a strong connection with Great Britain. We therefore think that the claimant under scenario 2 will fail to demonstrate a sufficiently strong connection, which means the claimant will not be protected by statutory employment rights under UK legislation. I would like to finish by discussing some practical matters that claimants and respondents should consider in these cross-border employment disputes. In cases involving an expatriate worker, there will almost invariably be an open preliminary hearing so that the tribunal can determine whether it has jurisdiction to hear the claim and to also determine whether the claimant can satisfy the sufficient connection test to be protected under UK statutory employment rights. We believe that in these cases, the tribunal will benefit from having witness statements from both sides and having witness evidence being tested under cross-examination. Failure to address relevant matters in a witness statement can be fatal, particularly to the claimant. For example, in the case of Rajabov and Foreign and Commonwealth Office, the claimant argued that one reason why he had a strong connection with the UK was because his employer promised him that he would be protected by UK whistleblowing legislation. This is something the claimant never addressed in his witness statement, meaning that the respondent did not have the opportunity to test this in cross-examination. As a result, the Employment Tribunal attached very little weight to such factor, something which was later upheld by the EAT. And so something to take away from the Rajabov case is that claimants and respondents should consider producing a very detailed witness statement addressing all relevant factors they wish to rely on to either prove or disprove the sufficient connection test, and that ultimately the tribunals want such matters to be heard in witness evidence and tested by cross-examination.